through his or her counsel, and the numbered word that you wanted to emphasize was indirectly.
Indirectly communicate.
Indirectly, correct.
Okay, let's read number 7. Can you please read paragraph number 7? Also word number 11. Can you read the whole thing?
Yes, ma'am. So 7, the defendant shall not communicate in any way, directly or indirectly, about the facts of this case with any person known to him or her to be a witness in this case, except through his or her counsel. And the word that you emphasized was indirectly.
And is this bond order, in fact, entered with Harrison William Prescott Floyd?
That's correct.
And signed and agreed to upon by both the state and defense counsel?
That's correct.
Who signed this order?
Counsel for the defendant.
And who signed the order from the court?
The Honorable Scott McAfee.
Did you have an opportunity to review how many times the post against Ruby Freeman were viewed?
Yes, I did.
How many?
Nearly 500,000 times. I think the approximate number is 466,000.
And in your investigations, have you had the opportunity?
This is beyond the scope of direct and cross-examination.
And the line of questioning is the reach of these posts, is it right? All right. We can open up that line. I think it's relevant.
And in investigations, I know you said you did not personally have a social media due to your line of work, but have you had the opportunity to investigate social media posts?
Yes.
And is it the culture of social media when one posts, people respond?
That's correct.
One moment, Your Honor. Nothing further from the state.
All right, recross.
So you researched Ruby Freeman's Twitter account, is that correct? Or X account? Is that what you're saying?
Miss Ruby Freeman, I'm not aware if she has an X account. I don't believe she does.
So she didn't even have an account on this social media platform?
Not that I'm aware of, sir.
Okay. And you said her name was referenced how many times?
No, sir. The question was how many times was the post in which Mr. Defendant Floyd references Miss Ruby Freeman, how many views did those posts obtain? And the answer to that is nearly 500,466,000.
Okay.
That's the answer to that.
And likewise, Jen Ellis has how many followers?
1 million, I believe.
Over 1 million, correct?
Yeah.
Now you said that Gabriel Sterling's going to be a witness, as well as Ruby Freeman.
Yes, sir. They're on the witness list. Yes.
Witness list?
Yes, sir.
Have you turned over that witness list to us?
I'm not sure of that. I believe you should have that witness list. I'm not sure of that.
Would you be surprised to learn that we don't have a witness list?
Yeah, I'd be surprised to know that.
Okay. And likewise, let's see. One moment. Where did you get that 500,000 figure from?
Simple math. Just looked at the viewership from each post that Mr. Floyd references Ms. Ruby Freeman. There's a little number at the bottom. For example, if you look, let's just look at State's Exhibit number 6. If you look at the bottom, it'll have the number of views. And so if you just simply look at all the posts in which Mr. Floyd references Ms. Ruby Freeman, there's several thousand views on many of those posts. And when you add them all up, when you calculate them, it adds up to about approximately 466.
And that depends on when you copied it, correct?
Say again, sir?
Does that depend on when you copied it?
When you say copy, do you mean
right,
when it was viewed, when I last saw the number?
Yes.
Oh, yeah, I'm sure it's probably more now.
Okay.
Yeah.
And in fact, this whole motion brought by the state and the attention drawn to Mr. Floyd may have amplified every one of those views of those posts, correct?
Possible. I mean, I wouldn't know the answer. Possibly.
Understand.
Your Honor, just very briefly, if I may.
All right, very briefly.
We've already admitted into the record 27, which is part of the record anyway, the bond motion. I'm on page 3 of the defense's motion at the second paragraph, 1, 2, 3, 4, 5, 6. Review that to yourself. And will you state what word does the defense refer to Ms. Freeman as?
So in this document, Defendant Floyd's counsel refers to Ms. Ruby Freeman at that line as a favorable witness. She is a favorable witness.
They recognize in their own motion, although they claim they're not witnesses, that she is in fact a witness.
Judge, we never said she wasn't a witness. Sorry.
I think that's accurate. I'm not sure what the point is here, where we're going with, but Ms. Wills, what's our next point here?
Sorry?
What's our next line of inquiry here?
In page 8, how do they refer to Ms. Jenna Ellis?
Ms. Jenna Ellis is referred to as a witness. Now
So
a
they
witness.
acknowledge them as witnesses, correct?
That's correct.
That's it, Your Honor.
All right, Mr. Hill, thank you. Investigator Hill, just to clean up the record, I think state tendered a exhibit 20. Obviously, we got state's exhibits 1 through 21 that were admitted. Then there was a 23, which was Ms. Ellis's response. I don't know if that was formally admitted. Was there a 22?
There is going to be a 22. It was pre-marked, so not at this time.
Were there other state's exhibits tendered?
26 and 27.
26, all right. And those were, I think, admitted without objection, if I recall.
Since I referenced an exhibit B and C, does the
The state has no objection to that.
I mean, I think one of them was just the response, which is already in the record. I don't think.
But letter B, exhibit B, Your Honor, is an exhibit which specifically shows, I'll grab it here.
Okay, and so if we'll just need digital copies of those provided, and we'll have those for the court reporter.
May I
Okay.
approach just to make sure the court has.
Sure. Just a moment before we do that, I just wanted to inquire, just so we are staying on track here. I know the state had mentioned there are 2 more witnesses. Did the defense intend to call any witnesses today?
I don't know yet, Judge. I want to see what they have put on.
Okay, but there's a possibility that 1, 2. What is the
Possibility.
ceiling of defense witnesses that could possibly be called? Okay, thank you. So potentially we have 3 more witnesses to get through, and we took about, 2 from the state and 1 from the defense. And we've got an hour and a half that we just spent on the first one. So in order for us to finish today, which is the goal, I think there were a lot of things there throughout that first direct that maybe would be more appropriate for a jury. And I'll just note that I'm very familiar with the record and I've read the responses, and I don't need quite as much hand-holding. So there's a lot that I think could just be argued and proffered. And if there's an objection to the proffer, you can make that objection. But in terms of how Twitter works or what the bond order says or who signed it, I promise you that I know that. So with that, I would ask, and I might be a little more willing to step in here if we can't stick to that. It's a state can call its next witness.
We will, Your Honor. We don't expect either of these to be as long.
All right.
We shall call at this time Mr. Gabriel Sterling.
You swear affirm to today's testimony should give according to truth.
Oh my God.
State and spare your name for the court.
Robert Gabriel Sterling, RobertGabrielSterling.
Good afternoon, Mr. Sterling. Where are you employed?
The Office of Georgia Secretary of State.
All right. And have you had an opportunity did you have an opportunity to testify at the special purpose grand jury?
Yes,
in the
ma'am.
matter that brings us here today?
Yes, ma'am.
I'm going to show you a couple of exhibits that have already been admitted into evidence. I'm going to ask you some very brief questions on them. Are you familiar with State's Exhibit number 2?
Yes, ma'am.
Okay, and just for purposes of the record, if someone tags you at gabrielsterling.org, do you in fact receive those? If they tag you here, then I'll go back and ask about that.
GabrielSterling.org is my old website. I think you're asking about
I'm sorry,
my-
at Gabriel Sterling, yes.
Yes.
Okay. And also, if someone tags at Georgia Secretary of State, is that something that a member of the Secretary of State's office, to include you, would receive?
Yes, ma'am.
Okay. And moving on to State's Exhibit number 7, have you in fact seen this post? State's Exhibit number 7.
Yes, ma'am.
And is that because you were tagged at Gabriel Sterling?
Yes, ma'am.
Moving on to State's Exhibit number 9. Are you familiar with State's Exhibit 9?
Yes, ma'am.
And is that because it was tagged at Georgia Secretary of State?
Yes, ma'am.
Is that what allowed are these tags what allowed these messages to communicate with you?
When you're tagged, it shows up in your feed of items that mention you. So yes.
Okay. And then finally, the last one, State's Exhibit number 8. Are you familiar with State's Exhibit number 8?
Yes, ma'am.
And is that again because you were tagged both at Georgia Secretary of State and at Gabriel Sterling?
Yes, ma'am.
Do you enjoy being called a piece of fecal matter?
No, ma'am.
Are you a witness in this matter?
Yes, ma'am.
My witness?
Yes.
Thank you. Mr. Sterling, you're not a fan of Donald Trump, are you?
Objection, relevance.
Goes to bias.
Bias against Mr. Floyd. All right. We'll give you a little leeway on this, Mr. Catrona.
You know Mr. Floyd is a Trump supporter, don't you?
Yes.
By the way, the state reached out to you about these posts, didn't they?
Yes, sir.
And they asked you to come in and testify about this.
They subpoenaed me. Yes.
They subpoenaed you to come here.
Yes.
These posts aren't threatening to you. They may not be nice, but they're not threatening and intimidating to you, are they?
It's par for the course when you're in a public figure.
So you are a public figure.
Yes, sir.
When you're tagged, the ampersand you said shows up in your feed.
Yes, sir.
That is a mention of who you are, correct?
The way it works is essentially when you go to for people who don't know Twitter or X, you'll have notification in the bottom part saying if there's a little bell, basically, if something mentioned your name or anything that you follow, you'll have a little red number in there to show you the new things that have happened since the last time you were there. And then you would go to that and you would see things where you were tagged in. Yes, sir.
Okay. I don't know if you have State's Exhibit 7 in front of you.
I have nothing in front of me, sir.
Your Honor, may I approach briefly? Showing you State 7. Where Mr. Floyd says, we want the truth. It's accountability time, unseal the ballots. Are you aware of other cases where the ballots are sealed?
There is a matter in Fulton County, yes, sir. It's actually being done in front of a Henry County judge, if memory serves.
So that post could be talking about that case.
I don't know what Mr. Floyd said, sir.
Right. We don't know what case this is referring to, do we?
Not particularly, no, sir.
May I have it back?
Yes, sir.
Are you also, you have approximately 67,000 followers on your account?
70,600.
70,600. How many direct messages do you get a day?
It varies.
Rough estimate?
I feel more like the week. I get 3 or 4 a week, maybe, depending. Like right now, I'm going back and forth with a gentleman about something going on in licensing.
Okay. And then how many times a day are you tagged on posts?
I have no way of knowing that, sir.
A lot.
It's common, yes, sir.
And it's common that you might miss. You're not paying attention to your notification section every single post that goes through there, are you?
When I'm tagged, I generally will go take a look at it, yes, sir. But I mean, it's not so overwhelming that I can't, but I don't look at it every day or every hour now.
And if you were threatened or intimidated, would you contact law enforcement?
If I thought something rose to that level, I would contact law enforcement.
And you didn't contact law enforcement in this case?
No, sir.
Your Honor, I have nothing further.
Let me redirect.
From the state.
Okay. All right. Thank you, Mr. Sterling.
Thank you.
Can this witness be excused from his subpoena?
Your Honor, at this time, we'll call
I guess so.
Du Bois.
I'm sorry.
Bond Du Bois.
Can you spell that for the record?
D-U-B-O-S-E, but we're gonna let him spell it as well, just to
Okay.
make sure the state got it right.
All right.
And this is our final witness.
Madam Prosecutor, who is the next witness?
Bond Du Bois.
Vaughn?
Mhm.
Is that law enforcement?
Not.
Is that a witness? Thank you.
From this hearing.
Well, according to the testimony, they will be the truth, the whole truth, nothing but the truth, help you.
I do.
You may be seated. Can you spell your name for the court?
My name is Vaughn Dubose, V-O-N-D-U-B-O-S-E.
And Mr. Du Bois, will you please tell the, for purposes of the record, would you state what your profession is?
I'm an attorney.
And do you in fact practice in this jurisdiction as well as others?
Yes,
Do you have a client that is a witness in this case?
I do.
Can you please state for purposes of the record what your client's name is?
Ruby Freeman.
I am going to hand you what has been marked as State's Exhibit number 22. Tell me what State's Exhibit number 22 represents.
Yes, I can.
Can you tell us, please?
Yes, it's a threat level report that we have a third-party vendor who will monitor online activity regarding potential threats for Ms. Freeman and her daughter and their family.
Why do you have a threat monitoring report that relates to Ms. Freeman and her daughter? And what is her daughter's name for purposes of the record?
Her daughter is Shay Moss.
You also represent Ms. Moss?
I do.
Is Ms. Moss a witness in this matter?
Yes, to my understanding.
And in fact, have you accompanied them to proceedings in this matter?
I have.
Why did you hire this company to do threat assessment on your two clients? Is that something you do for every client you have?
No.
Why did you find it necessary to do for this particular client?
Well, just the level of threats since all of this began for Ruby and Shay have been quite high. She's been listed on death lists. She's been told that she needs to leave her house by the FBI. So we just need to keep an eye on what's out there, whether there are any spikes or flashes in the threat level. So this company has been retained to do that.
And in fact, the threat levels at one point prior to this matter were so high, she had to relocate from her home.
Absolutely.
And that was on the recommendation of the FBI.
Yes, it was.
Prior to the state contacting you, were you made aware of some comments by a defendant in this case on social media?
Yes, I was.
What defendant were you aware of making comments as it related to your client, Ms. Freeman, prior to the state ever contacting you?
Mr. Harrison Floyd.
how is it that you became aware that Mr. Floyd, the defendant in this matter, was making comments about your client?
Well, a couple of my co-counsel informed me that there were some comments being made and that we needed to huddle together and have a session to assess what was going on and to determine whether there were any measures that needed to be taken by us or by Ms. Freeman and Ms. Moss.
To keep them safe?
To keep them safe, absolutely.
And in fact, as a result of these comments made by Mr. Floyd in relationship to this matter, did you call what you referred to me as a spike?
Yes.
Can you educate the court as you educated me as to what a spike is and why that may cause you some concern as well as the other team that represents her?
Sure. So a spike is simply a time at which online activity regarding Ms. Freeman, and her name is mentioned at a particular time, and you can tie spikes in this report to actual posts and things of that nature. So I believe this is the report that tied a particular spike in online activity to the tweets from Mr. Floyd. And traditionally, as these things go in this case and with Ms. Freeman, this is the beginning of potential threats. So that got our attention. We were very concerned about that, and we wanted to make sure we addressed it appropriately.
And so I don't want you to get into security precautions you took, but were in fact some precautions taken as a result of this?
Yes.
One moment. No further questions. Your Honor, at this time, I'd ask that State's Exhibit 22 be admitted into evidence.
Subject to cross?
State's Exhibit 22, you need to clarify some things before its entry? All right, well, let's start with that.
Okay. This is the report that you had put together.
The report is generated periodically.
Who is Protect Democracy?
Protect Democracy is a not-for-profit.
And so they're the ones that are generating this report?
No.
Why are they on here? Are you Jensen Hughes? Is that your firm?
No.
Why is Protect Democracy here for the date of November 15th, 2023?
Protect Democracy is counsel to Ms. Freeman and Ms. Moss.
Are there also an attorney?
Yes.
Okay, I'm sorry. I didn't know. Just asking.
Yes.
So this report, all these pages, this isn't all just Harrison Floyd, is it?
Not to my knowledge.
Right. It's other people like the Gateway Pundit, correct?
I think they're mentioned, yeah.
All these posts, all these videos, they're in the public domain, are they not?
What posts?
These videos of Ms. Freeman at the Cobb County station.
I don't know if all of them are or not. I can't.
So you have no idea whether these things are in the public domain already?
When you say these things, what are you referring to?
Oh, I'm sorry. Ms. Ruby Freeman's videos of her in the Cobb County police station being on body cam that night of January the 4th or 5th, 2021.
Okay. And I'm having trouble kind of understanding which particular videos you're talking about. It's hard.
All the Cobb County
in front of me, but
all the Cobb County police videos.
I don't know that for sure. I don't know if they're all in the public domain.
You're her attorney, right?
Yes.
Charged with protecting her?
Sorry?
Charged with protecting her?
I'm charged with representing her as counsel.
So you're representing her as counsel and you haven't researched what's out in the public domain about her?
That's not accurate.
Well, you don't know whether any of the Cobb County videos are in the public domain, right?
That's not
All
what I
right,
said.
and also, Mr. Katrov, I think the focus here was supposed to be the admissibility of State's Exhibit 22. That's the
I'm
pending
sorry,
question.
So this also includes other people apart from Harrison Floyd, does it not? Like the Gateway Pundit.
The state will stipulate that he is correct, that it is.
All right, and again, I think you're getting into argument concerning the document, not necessarily its authenticity.
I'm not going to authenticity, but actually to relevance because they're putting this in for stats in the spike, but they've included not just Harrison Floyd, but influencers on social media that have millions of followers.
And I think that goes to its weight, not its admissibility. So I'll admit 22 over objection, and you can go from there.
Okay. Miss Ruby's address is private, correct?
Yes.
Phone number is private, correct?
When you say private, do you mean?
It's not out in public.
Well, her address has been out in public, her previous address.
And have you spoken to her in the past few days
Yes,
about this issue?
yes.
And did she call the police about this issue?
No.
So Ms. Freeman also has a lawsuit against the Gateway Pundit, does she not?
That's correct.
And so this report was generated for that lawsuit?
No.
Nothing in the post that you've seen constitutes a threat under Georgia law, does it?
Which post are you talking about?
Post that the state showed you about Ms. Freeman today.
You're going to have to show me what law you're talking about. I'm not quite sure what you mean when you say a threat under Georgia law.
You're an attorney, right?
A civil attorney.
Civil attorney, but you know what it means to say threats, don't you?
I'm very particular about Georgia law.
So you don't know what a threat is?
I know.
Objection asked and answered.
Overruled, I don't think we've gotten an answer yet.
What's the question?
Do you know what a threat is?
I do.
There's nothing in his posts that are threatening, is there?
No, I disagree.
There's nothing in those posts that are intimidating to a reasonable person, are they?
I disagree.
I'm not talking about the follow-up posts. I'm talking about Mr. Harrison Floyd's posts.
I am too.
The threat level on this report doesn't show that the spike came from Harrison Floyd, does it?
It does.
It shows that the spike came from a conglomeration of sources. Have you read the report?
I have.
Judge, I have nothing further.
You redirect.
Questions for this witness from the state?
Okay, thank you, Mr. Du Bois.
Thank you, Judge.
That concludes witnesses for the state, and we do have some argument we'd like to make.
Of course, Ms. Willis. Any evidence on behalf of the defense?
No, Your Honor, we don't need.
Okay. Yeah, I'll hang on to that. Do we need a break at all?
5-minute break would be nice, bro.
Let's do that.
May I have access to the ladies' room that's there, please?
Morris. The jury room, or you saying she wants to go back here? You want to go to the jury room, or you want to go
Yes,
back?
that's fine.
Very specific, right? The guy told me it was like
Yeah, all right. Now that you said that, I had to look. Like, wow.
What's the full?
basically anyone with a mustache.
Not a guy from Burning Down. Burning Down, when they got mad at everybody.
Resources and mustache. Yeah, right there.
Okay.
Oh, that's great, yeah.
I'm sure.
Still like back and forth, still have nothing in my purpose.
Is it 5 minutes? Yeah. Look at this.
Are you also covering, okay, cool. Finally, that is like getting going now.
What's up? Asia. Oh, yeah.
I think you do that. Yeah. When it's red, it's not hot. It may have been out by the that's what I was thinking.
Yeah.
Oh, I'm sorry. Here, you need this. Oh, okay. So, the what?
Oh, yeah, no.
Well, I was at the first hospital. When she got taken to we were at the one at Airport. Oh, yeah. When she was on the call. I was there too.
Yeah. Yeah.
I was on tour with her. I wanted always got a big T. Nice guy. He's one of the kids. You know any people that you've been in touch with? I tell you what, I'll pass you along. Yeah, I guess so. My mom. What part of town? The guy, he's already been coached by Give me your card. I'll give you this. I'm so old school. That's how I guess it's very weird. Whatever you want me to give.
So we'll come to order, remain seated.
You know, she's still on? Okay. All right, we are back on the record. Ms. Willis.
I'm gonna waive any opening, closing, and I'll reserve everything until the end.
All right, I think the state would still have the burden for revocation, so we'll turn it over to the defense. Mr. Kaczmarov.
Good afternoon, Your Honor. May it please the court. I think if we anchor ourselves to the words of the order that you entered, I think that's dispositive. I begin there because there's really three things there the state is complaining about. One is the concept of intimidation or harassment. Is that a subjective standard or an objective standard? I would submit, Your Honor, it's an objective standard. Otherwise, this order is vague. We wouldn't know what those things constitute. Threats and intimidation are well defined in Georgia law. None of these posts amount to a threat or intimidation. That is to say, none put a reasonable person in fear for their safety. The witnesses today you heard did not support that paragraph. That would be paragraph 5 of your order. There's no violations there. The remaining two paragraphs I would submit, paragraph 6 and 7, there's no violations there either. Those two paragraphs state that you're not supposed to have any communication with a person or witness or a co-defendant in this case about the facts of this case. That's what those two, directly or indirectly. So if you look at that order, the only thing that the state tries to argue is that these handle tags on Twitter constitute communication. They said that over and over and over. The problem with that goes against Twitter's own help rules. And I have a apologize. I actually brought it up on my phone, and I would ask the court to take judicial notice of that. And it says the ampersand sign is used to call out usernames in posts. Hello at X. People will use your username to mention you in posts, send you a message, or link to your profile. So that in the Twitterverse, that's used in a wide variety of ways.
Sure, but the practical effect is that the person mentioned gets a notification, do they not?
They do, Your Honor. And I would submit to you, for instance, Jenna Ellis has 1 million followers. I would submit to you, if you typed in Jenna Ellis and give the money back, you would see hundreds of thousands of independent tweets saying the exact same thing. So I find it hard to believe that Ms. Ellis would have seen that unless she were specifically called out about it, which is the other thing. None of these witnesses here contacted the state. The state shows of its own volition to contact them.
But just to be clear, what you're arguing is not so much that it was impossible that Mr. Floyd's comments reached any of these witnesses, just that it was improbable.
It was improbable, yes. It could, surely they could see if it shows up in their feed, surely they can see it. But that's the other thing. Were they talking about the facts of this case? And I can go through each one of the Twitter posts that.
Well, it says that they can't communicate, right?
Not just communicate, can't communicate about the facts of this case.
And so, for example, with the one with Miss Ellis, how would that not be a communication about the facts of this case if it's solely referencing a proper session?
Because first, it's public in the public domain. Number one.
Well, that wasn't a precondition, right? Of the bond order.
No, but she's not. I'm just pointing out the fact that her video is in the public domain. He's commenting on the video. It is a public comment. He's allowed to do that under the First Amendment. So the idea that this is somehow not a permissible communication, it's a problem because that begs the question about the facts of this case. What facts? The ones as they develop? The ones that are ongoing? The facts in the indictment? I mean, which also spurs another question. Miss Ellis won't even be a witness against us. I mean, I know that the state's going to say, well, she's a RICO witness. We don't have anything to do with Miss Ellis. Not only that, we don't even have a witness list. All we know, we have unindicted co-conspirators. We have to guess who the witnesses might be. Now, the state has said that they have sent us discovery, but that discovery is like a football field, sized haystack about 10 feet high, and we're looking for 5 needles in it. I have to go through 30 or 40 folders and click down only to find out that the file that I'm looking at is a GIF image. So the idea that, well, we've turned it over. I don't know if they've turned it over. I had to search. I had to ask the other day for one of the witnesses' grand jury testimony that they said they had just received. So I don't know what the state has or what they don't have. I don't know who their witnesses are. That's of no concern to me.
Sure, but I think you have a pretty good indication of who they're going to be, at least some of them.
I didn't know Gabriel Sterling was a witness. Had no idea, Judge. Zero.
But what about the Secretary of State?
Right, but that's also a public account. He's not barred from calling out the Secretary of State. Now, if we don't like that, we should change the bond order. I would submit, Judge, that would be the appropriate remedy. The state surely, and you read my motion, the state, or my opposition rather, the state knows how to address social media posts as it did with President Trump.
And so again, this idea that someone has pleaded guilty and an explicit condition of their plea is that they're going to be a cooperating witness. You still don't think that's sufficient notice that person's going to be a witness in the case?
No. I stipulate. So we're clear on the record. She's a witness in this case, not against him.
Well, she's a witness in the prosecution against him. He's going to be sitting presumably at one of many tables, and it will be in the state's case in chief where he is a defendant.
I may be presumptuous in thinking that won't happen, but Judge, she's a witness to be sure, but nothing in that bond order prohibits him from contacting a witness. Nothing in the bond order prohibits him from contacting a co-defendant. They just can't contact each other about the facts of this case. They could call him and say, hey, you want to come over for dinner tonight? As long as we don't talk about the facts of the case, they could do that. That's why I pinpoint those words. Communicate with. That's the other part of this. It's not simply to shout out into the Twitterverse. That's like going to Mercedes-Benz Stadium and being on one side and Miss Ellis is on the other side and during the middle of an Atlanta Falcons game. And he yells out, hey, Jenna, give the money back. If she happens to hear it, and maybe the crowd starts chanting, give the money back. She's a public figure as well. 1 million followers, Judge. 1 million. She wasn't worried. She didn't know anything about it. She didn't reach out. So we're not contending that she's not a witness. The thrust of this is collusion. Are you getting together with other witnesses to change stories? I don't see any other purpose for those paragraphs 6 and 7. So I would submit, Your Honor, if we pay attention, if we're faithful to the text of the order, paragraphs 6 and 7 are clear. Communicate with, not communicate to, not say something about, because that's what this really amounts to, say something about. You heard Assistant Chief Hill. I believe his testimony was he didn't know what was in the mind of Mr. Floyd. Mr. Sterling contended that one of the posts, or he agreed, one of the posts he wasn't even sure what case it applied to, but he knew there was another case pending that had sealed ballots in it. So yes, when you're tagged, it shows up in your feed. But like I said, Judge, you're not required to, it's not a requirement in Twitter. I post things all the time where I will put an @ symbol. Do I think that the other person might see it? It's possible. I don't care. I want to post. It's a political forum. That's the whole purpose of ideas. I mean, you find something offensive, you don't have the right not to be offensive. I mean, in order to think, you have to risk being offensive, do you not?
So, yeah, just taking that point, I just want to focus here. I think maybe the Twitter aspect of this may be confusing it, but what would be the functional difference of Mr. Floyd having just written a letter and mailed it to him and assuming that Ms. Ellis gets 1,000 letters a day?
Because that shows his intent. His intent is to make direct contact. There's a mechanism in Twitter for direct contact. You can send a message directly to the person, as opposed to the Twitterverse, the forum, the public forum, putting out a political message, a political opinion. He can do all of those things. He can say, I'm innocent. I didn't do this. Now, is he talking about the facts of this case? Well, I'm sure the district attorney will try to use this stuff at trial, perhaps. But Harrison Floyd has never said that anything against Ruby Freeman. And by the way, Ruby Freeman doesn't even have a social media post. And I want to bring this report up. I would encourage you, Judge, look at page 2. A majority of these mentions related to commentary about the latest post from the Gateway Pundit regarding Ms. Freeman and Mrs. Moss's alleged participation in election fraud. Her attorney said this report was about his posts, but I don't see how you can compare the two. Gateway Pundit has a slew of followers. His Twitter account is 25,000 people, not 2 million, not 3 million, not the million that Jenna Ellis has, not the 75,000 that Mr. Sterling has, or the 114,000 that Miss Willis has on one of her accounts, and however many others she has on her other account. A lot of this has to do with being in the public domain as well. Nothing in any of the posts that he wrote about Miss Freeman show any threats of intimidation. They are merely statements that he is claiming, I'm innocent, I haven't done anything wrong, which is why I said in my motion, or my opposition rather, that this court should be faithful to the text of the bond order. If we have an issue with it, Judge, we're very amenable. You heard my co-counsel say earlier, all they had to do was call us. Mr. Floyd has come back to Georgia voluntarily. The first time when he turned himself in, he was put in jail, wasn't able to get a bond hearing until Your Honor got involved. And you got back and were able to get him a bond. He appreciates that immensely. He came back today just because I told him to. He's a law-abiding citizen. Yes, there are some other things pending, but that has nothing to do with this hearing. Zero. If the court tells him, look, I want you to tone it down, I don't want you to mention Ruby Freeman, he'll do what you tell him to do. It's not that at that point, it's not about a First Amendment argument. We'll let that go, Judge. If his rights to speech are in jeopardy versus his freedoms and liberty, his personal restraint, Judge, he's going to opt for his personal liberty. So I would submit, Your Honor, that this whole tactic is somewhat of a retaliation. If you look at when the motion was generated, I believe the motion was generated on the November 15th, just after this court's hearing, because we received it 2 hours after the court's hearing on the protective order. Miss Willis was in DC. She personally signed the motion, or they put her signature on it. She was attending an event with a women's summit and also a fundraiser. But the reason why I say it was cobbled together hastily was because Jenna Ellis's post is on the 13th, and she says she saw it a couple of days later. Well, I would submit, Your Honor, that she was raised, the awareness of that was raised to her by the state. I just don't see a million followers how that could happen. And so with that, Judge, I would just check one thing here. Yes, and there's also on Twitter, if there's a post that's found offensive or threatening, it can be reported. And people should do that. If they want to generate reports, they can. But it would be just as effective to call out posts and say these are inappropriate posts. So with that, Judge, I conclude.
May the state be heard. Your Honors, I always like when me and the defense can agree. We agree on something. We just ask you to strictly rely on the order that you sign. And as Your Honor knows, I only have to prove he violated this order one way, and that would be enough to revoke his bond. So I'll lead you to number 7 that says the defendant shall not communicate in any way, directly or indirectly, about the facts of this case with any person known to him or her to be a witness in this case, except through his or her counsel. It's clear they signed it, they understood it. Now I'm going to take some time and go through a PowerPoint. I didn't ask any questions today to offend you. I asked you because of the absurdity of their argument. My team asked me to tone it down because I referred to it initially as lunacy, and they asked that I refer to it as absurdity. I would submit you can use either adjective. I need a screen share. I need a screen share, Your Honor.
Which account is joining to
What account
host,
is joining?
Mr. Wooten?
It's under my name, Judge.
All right, just one moment.
Your Honor, I apologize for interrupting. Ms. Willis limited to the scope of my argument, or is she going to go?
We'll see if there's a point that needs to, we can go back and forth and back and forth. We don't need to have strict guardrails for argument.
The first one. Your Honor, just very quickly, Harrison Floyd was indicted by a Fulton County grand jury for count 1, conspiracy to violate, count 2, conspiracy to commit solicitation, and count 31, influencing witnesses. He entered a consent bond on August 29, 2023. The language was plain, and I still contend he violated 3 of the 7 conditions, those being 5, 6, and 7, but I just need one of them. Your Honor, the law is clear. It is clear that the trial courts have the power to revoke bond as long as minimum due process is applied. Your Honor, by this hearing, you've given him due process. The trial court has authority to revoke bond if following hearing, the trial court determines that the defendant violates those conditions. It is clear he violated the conditions. The standard of proof in matters initially setting a bond, the state has the burden of proving by a preponderance of the evidence that the trial court should deny bail to protect the community. Proof by a preponderance simply requires that the evidence show that something is more likely true than not. Condition 5, he shall perform no act to intimidate any person known to him to be a co-defendant or a witness in this case, or to otherwise obstruct the administration of justice. We've seen these posts, but certainly contacting the Georgia Secretary of State and Gabriel Sterling and calling them derogatory names is a way of intimidating. Whether it actually intimidated is not the result. It is, was it intended to intimidate? Moving on, he's about to go through some things. Your Honor has been practicing criminal law a while. Moving right along, this offense of Jenna Ellis, and I was going to point it out, but you already did. How we can contend that a proffer is not evidence in this case, and you're so dense, you don't know that the proffer is evidence, when in her proffer, the condition is that she's a witness. They want me to say it's disingenuous. It's a lie, Your Honor. This is Jenna Ellis. It's already Exhibit 23. I saw it a couple days after it was posted. Yes, I believe it was meant to both intimidate me. So does everyone else in the world who saw it, and to harass me, and also encourage others to harass me. That is common sense, but the witness has told you that is what she feels about it. Also, the negative comments that once again that Ms. Freeman has had to endure now for multiple years based on lies, he made sure that we're right back in that posture, and it's unacceptable. It is unacceptable for democracy to work. We need little old ladies to come and volunteer to be poll workers. And what this lady has received is a pattern of being lied on and intimidation, and he started it again. And I think we can both agree, being called outside of your name, older lady, I don't want to offend Ms. Freeman again, by this is disgusting, and it is as a result of his posting images, which are also evidence in this case. No one can deny, if you read the indictment, which they have been provided, that this is evidence in this case, which is why she's mentioned 40 times in the indictment, but they want you to believe they don't know she's a witness. It's ridiculous. I'm sorry.
Setting those, I agree with you there. With all the posts about Ms. Freeman, those are ones where she is not tagged. And so I know that we have State's Exhibit 22 showing that there is a reaction just to simply mentioning her. You know, would you agree with the defense that Mr. Floyd there's nothing prohibiting him from publicly criticizing the state's case generally?
What I would agree is that when he signed a consent order, and the First Amendment can be limited for parties in a lawsuit, and Your Honor limited it. And the case law is very clear that there is a public good of keeping the community safe that you are required to do, which is why you made those limitations, and that his First Amendment rights to say whatever he likes, if they interfere with the trial of a case, can be limited. And I'm going to take Your Honor.
No question that they can be limited. What I'm wondering is, though, were they limited here to the extent that he couldn't talk about the case at all?
They were limited in the fact that he could not talk about the facts of the case, referring you again back to paragraph 57. It's not ambiguous, it's clear. It's the black letter. Cannot talk about the facts of the case. This video of Ruby Freeman are the facts of the case, and it's in the indictment. Let me read you some of the law that we have, and this comes straight, Your Honor, from a Supreme Court of the United States case, Seattle Times Company versus Reinhardt, February 21st, 1982. So this is not new law. In the footnote, parenthetical 12 of 1718, although litigants do not surrender their First Amendment rights at the courthouse door, those rights may be subordinated to other interests that arise in this setting. For instance, on several occasions, this court has approved restrictions on the communication of trial participants, which he's a named defendant, he clearly is, where necessary to ensure a fair trial for a criminal defendant, which this could have impugned not only on his rights, but his 14 co-defendants still remain with him. Also, Your Honor, it says in that case, in the conduct of a case, a court often finds it necessary to restrict the free expression of participants, including counsel, witnesses, and jurors. Your Honor, you restricted it when you signed this order. Not only, what makes this so disgusting is he consented to this order. So this wasn't even put upon him. He agreed to this order. They want to tell you about 5 days. Those were 5 days he chose. They know that we tried to work with counsel, but that's irrelevant. He was given the benefit of the doubt. He was treated like every other defendant, although he had an open case. He was given an opportunity to cooperate with the rules of this case. And what he really did was spit on the court and refuse to oblige by 3 of the 7 conditions of this bond order. So no, he does not have the right to communicate about facts of this case with witnesses, which he did with Jenna Ellis, which he did with Sterling, which he's very well aware of and was served. And it is not the state's fault if the defense is unprepared, which was their argument. We're unprepared. We don't know what's in the discovery. Not my problem.
How is he communicating with Ms. Freeman in this post?
When you put something on a social media page that's reviewed by 400,000 and you put it in an open space, you have the ability to indirectly communicate with Ms. Freeman when you put it in the public space. Perhaps they could have some sincerity in that if he had a closed page that was not watched by many. Do you understand what I mean by a private or a closed page? That is not the status of his post, which is why close to 500,000 people saw it. Again, response, mentioning Jenna Ellis. Again, I guess they want you to believe they don't know Jenna Ellis is a witness in this case. On and on, Your Honor, and you have it. And again, I don't want to waste your time. And the response is just what you could expect. Ms. Ruby needs a bodyguard or she's going to get Epstein. This is a direct result of his conduct, which is why you, as the trial court, have a duty and in fact did your duty to keep witnesses in this matter safe. Moving right along, if she'll live to see this day, there's no denial that as a result of his conduct, a witness was put in greater harm and greater hate was again spewed against someone that's had to go through this for 3 years. Condition 6, he shall not communicate in any way directly or indirectly about the facts of this case with any person known to him to be a co-defendant in this case. I guess they want you to believe they didn't know Jenna Ellis was a co-defendant. You can look at the post, it's part of the record in here. Jenna Ellis again saying she saw it, which means there was an indirect communication with him. Your Honor, I just need to prove he violated the order once. He knew what he was doing. They signed this order. They agreed to it. There was a good reason to have an order with these conditions. And what we're really here to decide today is, does this order mean something or not? He doesn't get a, oh, I'm sorry, after I've already intimidated the witnesses in this case. It's too late. You should not have done this. You knew it was against the rules. You put someone in danger as a result of doing it, and now you need to be held accountable for it so that we can make sure that all of the defendants in this case get a fair trial and that witnesses are kept safe. Moving right along, Your Honor, you'll have all of these in your communication. There was some debate, again, lunacy and absurdity, that we don't know if this is Harrison Floyd. Your Honor can look at the post and see his image tying this to him. Jenna Ellis, again, in these posts. Authority of the court. Bonds in both felony and misdemeanor cases may contain conditions so long as the conditions are reasonable under the facts and circumstances of the case. I would suggest the conditions you gave him were reasonable, which is why they signed up to them and agreed to them. And Your Honor, it is not, we limit Fourth Amendment rights all the time in giving bond orders, giving someone the right to search. Same thing with First Amendment rights. Authority of the court. One of the court's functions is to balance the defendant's rights with the interests of the public. The public is Ms. Freeman, who served, keeping her safe. The public is also Ms. Jenna Ellis. The public is witnesses and jurors who will come and testify. Here, the bond conditions are not arbitrary and capricious because the conditions are a reasonable response to the trial court's functioning of balancing the defendant's rights with the public safety interests while avoiding the intimidation of prosecution witnesses, which was the exact purpose here. But Your Honor doesn't have to find it was intimidating. You can say, you know what, calling witnesses pieces of shit, it don't even matter. I don't find that to be intimidating. Do you find they communicated? Do you find that they communicated with co-defendants? Do you find they communicated with witnesses? If you find that, then you find that he violated the bond order, and you have to decide, do we have an interest as a society in keeping witnesses in this case safe? Do we have an interest in this case of keeping the other defendants from having a fair trial? Authority of the court. Although litigants do not surrender their First Amendment rights at the courthouse door, those rights may be subordinated to other interests that arise in this setting. For instance, on several occasions, this court has approved restriction on the communications of trial participants, which he is, where necessary to ensure a fair trial for a criminal defendant. There are other criminal defendants in this case. In the conduct of a case, the court often finds it necessary to restrict the free expression of participants, including counsel, witnesses, and jurors. Again, the site for that is Seattle Times versus Reinhart, 467 U.S. 20, 1984. Defendant Floyd violated his bond, and it should be revoked. OCGA Ayala sets out 4 factors a court must consider when setting a bond, including he violated 3 of the 4. His rhetoric poses a significant threat or danger to witnesses in this case and the community. He poses a significant risk of committing a felony committing trial. He poses a significant risk of intimidating witnesses and otherwise obstructing the administration of judges. The absurdity of the defendant's argument. Defendant falsely claims that he does not know who the witnesses are. Your Honor, that's just a lie. It's just a lie. There's no other thing to call it. You're not aware Jenna Ellis is a witness? So I know that it annoyed you to ask that question, but I wanted you to see in their own motion, they know she's a witness, and they should not have told you that. Defendant Floyd in his own motion refers to Jenna Ellis as a witness. Defense motion, page 8, line 9. Defendant Floyd in his own motion refers to Ruby Freeman as a witness. More absurdity. In indictment number 231888947, Ms. Freeman is mentioned 40 times, but putting the defendant on notice, she is a witness. In indictment number 23SC18947, Secretary of State Raffensperger, who he tags, is mentioned 4 times. I think that puts them on notice that he's a witness. The defendant has the witness transcripts of the Secretary of State, Mr. Gabriel Sterling, and Ms. Freeman. They are aware with these witness statements that they are witnesses. Defendant states in his motion affirmatively that Mr. Floyd's post did not stir the pot against Ms. Freeman. Really? You saw the post. It absolutely stirred the pot. And so for them to put that in their post when they saw, as he called them, the ugly, racist, violent comments, that is a direct result of his conduct. However, a cursory review of the response to Mr. Post show that this to be another lie. Miss Ruby needs a bodyguard or she's going to get Epstein. Ruby is, if she lives till a trial. I'd love to see her daughter in the slammer, 2 corrupt losers up into it. Bury this under the jail. Ruby should be in prison. She's a racist. Cause he's the one that's scared she's afraid of white folks. Racist pig. It's no question that that is not true. Dirty damn rats. All of it is untrue, so they should not have stated it in their motion. Defendant wants this court to believe when you tag someone in a post, it does not notify them. The entire purpose of tagging someone is so it hits their feed and they see the post. Take judicial notice of that, Your Honor. You don't even have to, though you have witnesses testify to it. They make this silly argument because it is clear that it's communication in violation of the bond order. They know it's communication. I'd submit to you it's direct communication. But it doesn't matter. If it was direct or indirect, he violated his bond order. In 2020, Ms. Freeman and her family members were intimidated by people as a result of her name being disclosed on social media. And it is this intimidation which Mr. Floyd was indicted to represent to the court that his recent post of accusing Ms. Freeman of the exact same things that were done before and indirectly targeted Ms. Freeman is absurd. Defendant wants this to court to believe that the last thing Mr. Floyd wants is for Mr. Freeman to form an impression he's somehow against her, except his post show that. Yet it is Mr. Floyd accusing Mr. Freeman of his post of being a fraud. Your Honor, all we're asking you to do is exactly what the defense asked you to do. Read the court order. Look at the evidence. He violated this court order. It is unfair to those witnesses that are just coming, first to do their public duty as an election worker, and second to do their public duty as a witness. And there are real consequences for allowing defendants to intimidate witnesses. Your Honor, we're asking that his bond be revoked and he be remanded today.
All right, I'm going to allow the state the last word, but Mr. Kasparov, if you have a few other points you want to make.
Yeah, I'll be brief, Your Honor.
Your Honor, as you know, I've not ever contended that Miss Ellis isn't a witness or that we didn't know she was a witness. I'm not sure where that came from. My motion said, our opposition says she was a witness. We admit that. The state's argument is that anything on social media posted about, that Harrison Floyd posts about this case is automatically an indirect communication, if not a direct communication. That's absurd. And that's where we're running into trouble here. Judge, I would submit you focused in on one particular tweet, which was Jenna Ellis. And I want to go back to her tweet. That tweet is a shout out to the Twitterverse at large. Yes, I think it walks up close to the line, but if you understand the world of Twitter, or X as it's now called, that's not how people communicate. It's a very ineffective way to communicate. If he really wanted to communicate with her directly, he would have simply sent her a notification and called her a liar or whatever. And he could have even called that out. That would have been a clear violation of the protective order. The other point that the district attorney made was that, oh, we said we didn't stir the pot. Yeah, we didn't stir the pot. You see, the district attorney stirred the pot. They've been stirring the pot since he got arrested, Judge. From the very first occasion, I never got a call about Mr. Floyd getting bond. Rather, I have Ms. Willis and Mr. Wade apparently recorded my colleague up in Maryland, which, by the way, it's a two-party state. It's a felony to record without permission up there. They recorded my colleague, and he said, I don't know anything about the bond. I was handling his case to come here to Georgia. So this idea that he's been given all these chances, et cetera, I think that's hogwash. Now, This idea, though, that we didn't stir the pot. All the evidence that you have, the views, they are wholly dependent, Judge, when they were captured, when you looked at Twitter and when you captured that image. When they filed this motion to revoke bond, just like when they filed the motion for the protective order, if you recall, Judge, I was in court and I said we had gotten numerous calls from the media that they were pestering us, and you said, well, we should all expect some of that. And I agree, we should in this case. But this is not exactly right, because when they file a motion to revoke his bond, they're all in the back watching us. When they file the motion, it immediately causes a spike and everybody starts searching everything. So they can't use that as evidence against Mr. Floyd. I think that is absurd. The other thing I would leave you with, Judge, I really believe that the words of this court order are pretty clear. And I think the only thing that you have to discuss or to analyze today is whether you believe he was communicating with Jenna Ellis in that one post. I think that's the only issue that you are faced with, because it's an indirect tag. Now, it's not an indirect communication, and as I've said, the Twitter help file is just dispositive on that. It's a shout out to the Twitterverse. Could it be used as a direct communication? Well, indirect. I'm sure it could be used as an indirect communication. But if you search yourself, Judge, and look up Jenna Ellis and send the money back, I think she raised over $200,000 and before she entered her plea, you'll find hundreds of thousands of posts telling her to give it back. Now, maybe she was directed to Mr. Floyd's at some point by the state. I don't know. We don't, and we should not chill speech. He has the right to make political speech. He has the right to talk about the facts of this case in Twitter, as long as he doesn't communicate with another defendant or a witness. Now, we don't know all the witnesses that are in this case. Like I told you before, I know a fair number of them, but I have a list of unindicted co-conspirators that I'm just trying to figure out who they are. We don't exactly know. I don't have a matrix of that. If we do, it's in the discovery somewhere, and we're still searching through that morass of information.
So you were not provided the witness list used during the trial we had prepared for Mr. Chesbrough?
No, I was not, Judge. I don't recall getting that list at all.
All right.
If they did, I couldn't sit here today and tell you they didn't put it with this mountain of stuff, but the way they turned over discovery, I've never seen anything like it. They just handed, 80 folders down, yet you find this one little GIF image, a little picture that belongs to another file that's down a different tree, 50 folders. It's absurd. That's absurd. So at the end of the day, I think the rule of lenity is appropriate here. If the court feels that something is amiss, or when you want to correct something, or we need to make something more clear, I think we need to give Mr. Floyd the benefit of the doubt. This is not giving him a second chance. I'm not asking for that, because I don't believe he violated the words of the bond order. I think the bond order is crystal clear. Do I think he walked up close to the line? Yes, he did. Have we had discussions about it? Sure. But in terms of the last part with the 13th and 14th, when we were accused of, quote, leaking a video, that video wasn't leaked. There was no protective order on any of those proffer videos. That wasn't even a leak. Yet Mr. Floyd's November 13th and 14th posts are responding to that purported leak, because the district attorney absurdly put in that a typo from my colleague where he said, we are the source of the leak. And he then sent another email back pretty quickly that said, we are not the source of the leak. I'm sorry, that was a typo. I typed too fast. They did mention that it was a typo in their motion, but they only included one email. The press picked up on that one email and things started to go crazy. That's the nature of this case. So if we're going to limit speaking, every time Ms. Willis goes to Washington, D.C. and attends one of these events, we get spikes in Twitter. The same time that he was making these other comments, that's when she was in D.C. at these events. So the words of the court's order are clear. The burden has not been met by the state I'm positive the burden has not been met for the concept of intimidation. That's a legal definition under Georgia law, and it requires one to be objectively and put in reasonable fear of harm by the words that were spoken, not by responses, not by any of that stuff. And then with respect to the last two, paragraph 6 and 7, You won't communicate with. It means alongside, I won't go to this man and say, I communicate with you. I want to talk to you. As opposed to me addressing you here, knowing full well he can hear me. And saying, well, John Morrison is our co-counsel. I'm not communicating with him, but he can hear it. So the idea that he didn't communicate with about the facts of this case, as I want to express to Your Honor one more time, it's not that he can't talk to a witness or a co-defendant. What Ms. Willis said about that is absolutely incorrect. That's not even what the court order says. The court order is specific. You cannot talk to another witness or co-defendant. You cannot communicate with them about the facts of this case. The whole purpose of that number 6 and 7 is to avoid collusion. That didn't happen here. What we have here are First Amendment issues. If you want to curtail, I would submit, Your Honor, we should adopt what the president's bond conditions, where they explicitly mention the First Amendment issues on Twitter, because the president is known for that. So if they felt that this was included in his bond motion, they should have put it in there. They had the opportunity to do that. Thank you.
Your Honor, I'm not going to be long. The bottom line is the defendant didn't respect the order of this court. He violated it. If you have questions about intimidation, don't go to that paragraph. Go to paragraph 7. Although you have a witness, Ms. Jenna Ellis, telling you she felt intimidated, and Von Du Bois, who represents another witness, telling you that he interpreted, that his team, to include his client, interpret that as intimidation. But you don't need it. All you need is paragraph 7, which says he's not to communicate. This notion that tagging someone doesn't get a message to them is really lunacy.
All right. I'm going to compile my notes and I'll be back in 5. We can hold in place.
Right, exactly. I gotta send photos. I'm gonna get a power strip.
Yes, he did say 5 minutes. 5 minutes. About 2.5. Bill Wooten, WILL, Wooten. Yeah, WOOTEN. T is in Tom, E is in Echo. Is that it? Yep. Okay, and that's Mr. Wade? Yes. First name, Nathan. NATHAN. I don't know. I've been trying to find out.
Sorry.
Your name?
Daisha, D-A-Y.
Daisha?
D-A-Y-S-H-A.
S-H-A?
Mm-hmm. Middle initial D.
Daisha.
D. Young.
D. Young.
Yes.
Young. All right. That's good. D-A, I think it added an apostrophe in there. D-A-Y-S-H-A. Daisha. Like that? There's a Y after that.
Yeah, I don't have,
D-A-Y.
no objection.
Daisha, okay. Take that.
No, you can just put them up there. He has them anyway.
All right. Fix that. Yeah, we're good? ADAs. We all have different titles, but that'll work. Well, titles are important. Google.
Look at my Oh, okay, my bad.
You see our shoulders just came out? I got to take more like one up.
George Washington. So was it
Tough breath.
But when I come to order, remain seated.
All right, thank you all for your patience. So just a few thoughts to share. And the first, I would just say how we got here. At the outset, I'll just note that at the time of indictment, we were in this courtroom in the middle of another murder trial, so I was not able to conduct the first appearance for Mr. Floyd. But throughout that week during the trial, we were presented with these consented bond orders, which were negotiated by the parties, and that I signed without a hearing. And Mr. Floyd agreed to abide by the terms of it. And I think it's clear from the case law, there is no constitutional right to bail. And a bond can contain special conditions as long as they're reasonable under the circumstances. And often those can curtail or even eliminate defendant's constitutional rights under the First Amendment, under the Fourth Amendment, such as forbidding contact. We see that quite commonly. And the question becomes, a trial court has to balance the rights of the accused, as well as the public safety interests that are raised by any particular case. But I'll also note that a defendant is generally allowed to publicly criticize the merits of a case, to say that the prosecution doesn't have a case to challenge the strength of the evidence, to speak his mind. And I don't see anything in this consent bond order that limited general criticism of the state's case. Each of these conditions had components to them, had preconditions, but there was no general limitation of talking about this case. But obviously that criticism cannot cross a line and ever evolve into witness intimidation. And I think as the defense was willing to concede here, Mr. Floyd seems very boldly willing to explore exactly where that line lies in this case. And I think the state has made a compelling argument on many of these points. But in categorizing these statements, on the first point of intimidation, we don't see, as we might see in these bond conditions, as they're traditionally understood, someone posting the personal info of a witness or a co-defendant. We don't see someone directly messaging, again, as that's traditionally understood. And we don't see in the wording an explicit indication that something ought to be done about these individuals or that they should be targeted in some way. I read these as seeing more that someone is wanting to defend his case in a very public way. And so on the question of, and especially when it comes to the public officials, I think we've, as Mr. Sterling testified, when it comes to intimidation, they've endured far worse than is presented in this motion. I think it becomes a much closer question when we start talking about whether this is direct or indirect communication. And we're getting into also kind of a question of at what point is someone responsible for the response of others? And I don't know if those are necessarily settled questions under the traditional bond limitations that we used and the phrasing that we used in this case. And ultimately, I think that, first of all, the defense argument that there was no knowledge that these were potential witnesses. That's not an argument that I'm buying. I think that we can't hide behind a veil of ignorance when certain witnesses have testified before the special grand jury or are very much known to be involved in the facts of this case, or just recently pleaded guilty and were known to have a public cooperation provision. I also think that when we're talking about the facts of this case, that is a broadly understood term. And if someone is just denigrating another person who's known to be a witness and talking in reference to their proffer, that's also satisfying that precondition. But when it comes to the question of indirect communication, again, I think it comes down to, while there may, I do think that in several instances here, there has been a technical violation of Mr. Floyd's bond, and that communications he made wound up before the eyes and ears of potential witnesses and co-defendants. But not every violation compels revocation. And so I am stuck on the question of notice, and that the bond conditions as written in my mind were not specific enough to account for the nuances of social media. So I think the ultimate result of today's hearing is that it's very clear to me that this bond needs to be modified. And I think it needs to specifically prohibit any public comment concerning Ms. Freeman, concerning her daughter, and concerning other witnesses that need to be included, because even if he's not directly or indirectly communicating with them, however we define that term, I think the public safety interests raised as a result of today's hearing indicate that his actions have a consequence. And because he's under the conditions of this bond order, the court has the ability to curtail and protect that interest. So ultimately, what I would be asking for is for a recommendation from the state, but I would also allow the defense to respond of exactly how they would propose adding or modifying these bond conditions. And I will then take those under advisement and enter a modification on the record. And nothing from today's hearing should be seen as curtailing the state's ability to refile such a bond revocation motion immediately upon an additional violation. And I think that it also is very much dependent on the specific facts of the tweets and communications at issue here. And it can't be so broadly defined to cover all other co-defendants. So on the issue of modification, I think that's something that we can revisit and let time to consider, unless there's something the parties would like to address now and want the court to be able to consider specifically what they would like to see as a modification. Or that's something we can follow up, but the court is available and ready to enter that as soon as it's conveyed. Anything, Ms. Willis, that you would like to add?
Obviously, we're very concerned about the safety of Ms. Ruby Freeman. She has clearly endured enough. And this conduct is not just chilling to her, it's chilling to other people who would want to serve in her capacity. So, you know, we respect the ruling of the court, but take exception. This defendant is very well aware of what happens when he tweets about Ms. Freeman. We do not believe it is appropriate for him to make derogatory comments about anyone. He can publicly criticize me all he wants. I don't value his opinion, it doesn't matter. But what he may not do is publicly do things that intimidate witnesses. And so that needs to be clear. He should not be able to tag them so that they are communicated with, or put them in open space so that Ruby Freeman now may have to move again and get another advisement from the FBI. And so I would ask that before Your Honor leaves here today, that my team be allowed to sit down, that the defendant personally sign off on an agreement stating that and initial each clause so that it can be made more clear that he should not contact and intimidate witnesses in this case.
I don't have any concerns with what you've raised. Mr. Morrison, Mr. Kacharoff.
Briefly, Judge, I'm not going to sit down and initial language that I haven't seen, number one, or had time to look at, cogitate, ruminate, pontificate over. I think the appropriate thing for us to do is what you've suggested. We'll submit our orders. If you take what you think is appropriate and reasonable and enter it that way.
Well, then I'd ask you stepping back today, and then when we can get it worked out, then he can be loose.
Well, I think there's still time to the day. Why don't we see how far we get? I'm not going anywhere. And again, I don't think we're writing a treatise here, but I think there needs to be something more explicit and a little bit more definite. And it can be as all encompassing as we need it to be. And if we need to go back on the record about that, we can. So how about I will check back in with everybody closer to 5, and we'll see where we are. And if we need more time, we can take more time.
Your Honor, does the court have a jury room where we could be?
We do have several rooms. I think the state could use the jury room if they'd like to, and we can find a side room here if we can unlock that for you. Deputy Scott, is that unlocked? All right. All right. So the adjoining courtroom is also open.
We're gonna, I guess, look over some motions.
All right. Long time no see.
I'm not sure.
Yeah, what were you talking about?
Yeah.
So you said you got your own.
Oh my God, there's one that's not happening. No, I will be gone.
Oh my Yeah.
Both sides, yeah.
I see someone so then I was up until. Okay, I like so embarrassed now. Everyone heard my story about me.
I was gonna come up today.
I was going back to
Diary. I'll see you around.
get back on when
Well, I got 80% left, so I mean, if I need to change, I'm good.
Okay, if not, just, you can, I mean, it's 4:30, so it'll be half an hour.
How's everything looking?
It's good, it looks good.
Okay.
And we are commenting on his read sheet. Alex,
Yes, it is. Thanks. No, I appreciate it.
Oh, this guy. Okay. All right. Got you. Go now real quick. Go now real quick.
it's so funny because I I was like, oh, it's gonna be 30 minutes.
Hey, did you see him? Yeah. What is that? Okay. You can stand inside, move your hands. Okay, it's 45.
Radio. Where can you tell us in the back end service on the 82 leaving 901 Rice Street for the Atlantic City Detention Center? 2 female inmates. Mama giving mileage is 088527. Transfer 63rd. Oh, that's recorded on radio.
Yeah.
Thanks. Yeah, stay. Hey, Joe, you going? Yeah, I'm out, brother. Make sure you call. I'll call you tomorrow. Okay. Yeah, awesome. All right. I'm back. Yeah. I didn't want to buy two. I mostly want. So I trust. That's a good story.
Tomorrow. Yeah.
I was like really lucky. Still hold together and stuff. They worked for 2 years. But like it's like, small town. I think it's just like really seeing the view, like not from a small town, but like a smaller town.
Yeah, definitely. It's
Like
like a suburb
mid,
of a small
yeah. It's gonna be like
I'll be here on the 15th.
yeah. Last time I was what they do.
Oh, really?
Yeah, so it's not one of those things where you have to be there, like, there's all district court stuff.
They are.
So last time, we came, or stuff, he was only like, and it's just like,
Be my preference.
It's really neat, be able to describe like judges, their it's really hard to just certain can tell the difference between two judges in terms of the voices. Just don't know.
So funny. My mom will love her. This dress. I don't have to find a picture of it. I was telling her, don't have that on the walls. Watch this.
Stop.
Yeah. It's like, he's like, you look at that guy. You're usually cartoons. Yes, exactly.
I like those shoes, man.
That's really
These I had a pair of those and I couldn't find those Adidas, right?
No, these are, I think the Air Max.
Oh, yeah, Air Max.
Yeah.
Nike. Adidas had a pair of similar that I wore maybe about 4 years ago. And I tried, for some reason, all of Nike, it was a Nike, right? All of the Nike shoes were too tight. They got a pair out now that costs about $160 or $170. love the way they look, too tight. They comment on his green outfit. Everybody, yeah, lucky strong today. Yeah. It's like crazy. It's like, well, I'm on vacation after this. Tomorrow through Friday, then I got to do the Georgia game. We're gonna do like a show before the game, like a 30 minutes to an hour show, probably an hour show before the game starts, because it's on our network. So, hey man, hey, can you run me the battery up here?
1649 radio. 1649. AAPDC. Anybody 088531. 8531.
What is Sterling's first name? You know Sterling? Sterling, the government official. We can check on them, they say they put something on paper.
I can't do it. Try that stuff up small.
Gabriel Street, thank you. That green came in handy today. Lucky charm. You know, a Tory Lanez trial in California, he came to court in a green suit. Didn't work good for him.
The angel.
Yeah, do you have your recommendations? Appreciate it, man. I ended up walking out, everybody's gone. So, thank you. Yeah, it is. That's nice, especially when you gotta look all nice. Yeah, that's all. Good. You don't have a list about what term?
We're still making out with you. You have one?
I don't either. You don't have. If you want one, right? I would rather not have one at all. So if y'all want one, give us some stuff. All right, then we'll talk about it. All right.
Get back over that way.
I guess so.
Way by way. Tell you one thing, you have these things on for me. Better on that. That's why she looking down on mine. 9% to 44. 13. Where you at? 13.
It's the range back.
All right, that's it. Perfect.
I don't.
Oh, is it? I'm sure you'll sexy it up. So it's getting yeah. I didn't let Mr. Wynn. Got a car.
Chris?
Take a roll back for me. Take a roll back for me.
What's that?
Do you have a card?
I never showed cards anymore. I'm gonna hand write it out for you. There's only people that ask for court orders. It costs money to get them cards.
I haven't used one in 10 years.
See? Huh?
Pretty soon people say, you
I
have
don't
a
know why
QR
it's
code? That's a good idea. I should put a QR code on a business card. Yeah, well, who does it nowadays? Or mine?
Where you going?
I bet you're gonna eat good on Thursday. Like a man.
Well, we had a great dinner. Waitress asked her what she wants. That's right. He said, I wanted to market.
I forgot to put the name of my firm, so I put it down below. That's the name of the firm. It's not my fault. Catcher. KACHOUROUFF. Are you the court reporter? Oh, okay.
You didn't say yes right away this week.
Thank you.
Say this week.
Yeah.
You can say it.
This job isn't to form an opinion, his job is to work with facts.
Can you thin me out a little bit on the photos? Can you thin me out a little bit?
I did that already.
Hey,
Say hello to you.
Man, she can't get past it.
Nice to meet
Like that?
I did.
And she won't, you know.
And that's currently going.
I mean, look, she came here and argued this herself. I couldn't talk to him. That says something.
Okay.
Yeah. The fact that you're allowed to
Really?
criticize the state's case against you.
They just sent me a text and it's like,
Really? Because it's red.
tell me what I said.
Okay.
I'm an adult.
Let's go back to green.
Close to 60.
I can get to go to green.
There it is. Is it supposed to be green? Yeah, it is now.
Here's talking shit.
It was on red.
Yeah, it was on, it's red is on, green is on.
It was off.
It was on red.
Yeah, it's been red.
Behind this.
Oh, it's that one.
I'm just, it's okay, you just go back there, you tell them I said what I said. No.
So, but red is off.
Yeah, red is on.
Okay, thank you.
When it come back. It's like Devo. When they come around, I'll be quiet. When they leave, I'll be fine.
Yeah, I don't look at my phone, but he was texting me the whole time. This thing doesn't sound.
I knew it was good. I just say it. Trigger, man. As soon as I get back to my phone, you know what I want.
Oh, there we go. Oh, no, it it just wasn't green again.
I was nervous about that.
I was still on it.
This is all that you got.
Oh, thank you. Thank you.
I'm about to say, if the any obligation is
I wonder if that is all.
No, it's off.
and you know why, right? That.
This side.
It's the corporate action. So.
It just put me in a mindset of.
It's not something I think I've ever So does that count as
That's all. That's funny.
Yeah, it's David.
Well, I mean, this one easy with the law school.
Hey, it's not good.
His initials.
If we get that. It's gonna be one day. So I think it's yes, you. He's talking over here. Baby keeps trying to put me in here. The generator.
It won't turn off. It's right. See it turn off. Last time. It's better to get a plane. It's better than it's nice to meet
Check until this Friday. Stands even at 64 November.
I was gonna get wrong. If I get my heart teeth. Yes. Good. Litigation nowadays. Why did I try to do that?
Somebody said.
Yeah, Dana. Hey, a little more. So it's still.
Not as you, Rex.
Oh, person. I know you was on there. I'm like, I remember you saying that you were gonna cover it, but I thought you was covering the actual truck. So I was respecting. Listen. There's one thing I can say. It's not good. They all money shots. One thing I say, I never dismiss what you do.
I'm gonna go live and talk about it.
Okay, yeah.
And one thing I learned about this quickly is that we wanna walk with people we don't like. You'll get some issues. Go to the made 1 million views.
Listen,
I got you, I was you.
Get your feet by coming past the bar.
Yeah, okay. Too much. I was trying to get in trouble.
Oh, you were.
All right. I was waiting for you to chime in.
That's my whole style, separating everybody with long hair. You got time short. Yeah, clip on.
So we trying
One thing I don't know is I have not learned how to go task.
Good same church.
He's at mix.
Are you instrumental? Non-instrumental. He's instrumental. I know what part of I was raised in the church press. I was excommunicated. That's it. So I don't have instruments. Because it's not the New Testament. So this one's just a show. So that's good. That's all he sounded X about. Yeah, it's not a pen. Mr. Calls. Seems good. It's unbelievable good. When it's bad, it's unbelievably bad. Especially if I'm leaving. Oh, oh, church. Oh, yeah, it's great. I'll be happy to live. Oh, yeah, good. Yeah. 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 Oh, Sunday morning, Sunday night. And then it was that's why I'm 30 times over. Wait for somebody. So I go like this. Verse number 6, I go up the aisle. He's going. He's going. Just says I was allowed to. Go on. Trouble. My wife went to party. Yeah. Hey, you guys know if you want to talk outside, the cameras, we'll have cameras on. How do you think things went today?
how do you think things like go?
Oh, is that directed at me? No, I'm not answering. He's on the road. Yeah, right.
If you go home and see my daughter, that's fine.
Gets to go home to Thanksgiving with his daughter. Yeah.
Beautiful over there.
It's supposed to be like.
It's a long time.
They're trying to break all they were just waiting on us.
Sure.
I'll go through all that. Yeah, you got what's out front, all that.
Because who is living in Iowa? Yeah.
I think they're different by a couple of the ones. I hope they're gonna do like very much for their way home.
If you want to call it the Sally Port entrance.
The drive-in.
Yeah, it's okay. You like the game. I don't like the game. Sally Port means. They drop the gates on. That's true. It's not there. Can I try to anger him?
Place flying right. Huh? Yeah, get this person. I should probably call him
He's best.
I want to tell them, you thought we could do it. Lead the bar today, just for the record.
Yeah. And we had a live Monday.
Yeah.
Friday.
It was cold.
It's not.
So what? That's what someone. It does. How much can I make? How much more charge for this? This is. Not a lawyer.
Green is not, green is.
His shirt is trending on the internet.
What's that?
His shirt is trending.
My shirt is trending?
His shirt is trending.
Mine? No. Harris.
Yes.
My jacket is trending?
Your jacket is
Yeah, they
trending.
like it.
Oh, my jacket is trending?
I let him borrow it.
On Twitter, right? What's it trending as?
X400 on his Twitter.
Yeah.
Lucky Charm.
Lucky Charm?
Yeah.
That's nice, that's dope.
Yeah, that's better.
I got some more, don't worry.
Yeah, we can't say anything. This thing's on.
Yeah.
Yeah. Yeah, it's like
That's gonna set up an alarm.
1,000 minutes, I guess.
That's work.
roll call.
Call will now come to order. Remain seated. Okay. All right, we remain on the record, and I've been provided with a proposed modified bond order for Mr. Floyd by the state. And was there anything for me to review from the defense?
Yes, Ron, I did see the order. We have like just a few bullet points that we felt.
Okay. Can we get do we have an extra copy? Can we print off another?
Well, are we able to see those recommendations?
Sure.
No, well, yeah, I haven't seen those. And if we could give and I think there's a good bit for the defense to consider and digest here. But I don't have a copy. Well, the state's looking at the defenses right now. Okay.
No, we don't. Tender this.
Yeah, I'll take. Did the defense get a copy of the state's proposal? Okay, that's going to take a minute to review. So while you're doing that, and we might still just need to wait until we can actually discuss this in depth for a few minutes here. But I'll just note for the record, the defense proposal here is handwritten that says no tags, no DMs, emails, texts, or calls. No Ruby or daughter, but can respond if Ruby says something about Harrison. State provides a comprehensive list of witnesses, but Harrison can respond if mentioned by a witness. No statements by the state that criticizes Harrison. Okay. you think we're going to dive in?
I think we're ready to dive in.
Okay. All right. Well, let's use the state's modified bond order as our working copy. And we can just try to go through this paragraph by paragraph. As I read it, 1 through 9 on the first page are essentially duplicative of the original bond order. Any concerns with 1 through 9?
Yes, Your Honor. Specifically, I don't believe number 2 and number 5 were included in the original bond order. Those two are different.
There was he has to report. I don't know if I brought my original copy out.
The only reason why I say that is he does report it. So.
Yeah, that one does seem familiar. Okay. You probably don't think
Yeah. Okay, yeah, that's fine.
Okay.
Travel back and forth. Okay, right. And number 5 shall have no contact. That's different than the order.
Sure.
I don't think that's appropriate. I think the issue here is shouldn't be, well, we obviously, we don't want him to make statements that would inflame folks one way or the other. Go after somebody. That's the intimidation one. That's I think that no contact order, almost like a protective order. That's a little bit extreme. If the president were to call him, he couldn't talk to the president because this would be a no contact order. The president's order doesn't have a no contact order. I think there needs to be some kind of a carve out.
Hold on a second. Just remember, y'all, we're on the record, and so we need to make sure that we're speaking into the microphone because our court reporter is remote. Okay, so just to note, so originally we had as shall not communicate in any way with any person known to be a witness or a co-defendant except through counsel. So now that has essentially kind of been consolidated to make it very, very clear that it's just no contact with any co-defendant witness or anyone specifically named.
And we believe this is in Defendant Trump's motion, if you want to pull it as part of your record. That
Mr. Floyd, it's not your turn. So it's in the co-defendant's bond order.
in the co-defendant's bond order.
All right, so Mr. Kacharov, is there a specific witness, co-defendant, or person named in the indictment that you think there should be a carve out for?
First of all, for those that are respecting counts 30, 31 for sure, that would be Stephen Lee. That would be Trevion Foodie. Unindicted co-conspirator number 23, who we believe to be Harrison Douglas.
All right, but just so I'm clear beforehand.
Remember, it was no direct or indirect communication about the facts of this case. This is absolutely no contact period.
Sure.
So that's the difference.
And so you're saying that the difference here and what's needed is that Mr. Floyd should just be able to casually keep in touch and stay up to date just on a social level with these three individuals?
No, I mean,
if it's not about the facts of the case, I mean, were they personal friends before this indictment?
No. I don't understand the difference now. No contact versus communicate. What does that mean?
I think it's just making it very explicit. No contact.
Can't shake his hand. No, that's no contact. Well, that wasn't in there before. That wasn't any part of the allegations of state, and I would object to that going in. I think that's just a bit onerous for the occasion.
Well, onerous in that, how does it change what he's already been doing the last, what are we now, 4 months? I understand your point, but what I'm saying is
it's communication contact. Because if it is, we're being duplicative in the court order. You know.
I could say there's, sure, I could see that there's some overlap with 5 and.
If there's a specific concern, like you don't want him to be contacting Ruby, fine. Don't contact Shay, fine. I don't have a problem with that. We're not interested in contacting those two folks.
Your Honor, may I speak? It is typical in bond orders that co-defendants are not allowed to contact each other, and they are clearly co-defendants in the case. And so this is not an unusual request.
All right.
She wasn't there before.
Sure. Noted, but it is a very standard condition. And I would say safe to say almost every single case. That being said, I do wonder, is there any need now to have 11, 12, or 13? Or do we think 5 pretty much swallows those?
Your Honor, we want to make sure there's no misunderstanding here. And so we'd rather you make it perfectly plain. If you think it's unnecessary, I certainly don't want to be back here in 2 weeks because it was unclear, contact, communicate. So we think both adjectives are necessary since.
All right, Mr. Gattro.
What this does is effectively muzzle him from saying anything. Nothing about the case whatsoever. And I think that's not appropriate. I think to understand what the issues are. He can't, he can't even say anything on social media.
Well, where do you see that? So now I guess we're getting more into the more substantive new additions from the state.
Like number 10.
Number 10, we have.
And the contact provision now as well. The defendant shall make no public statement of any kind concerning any co-defendant or witness in this case or concerning any person specifically named in the indictment. So beyond witnesses, even, including himself, maybe. That's the other part of this. This shall include, but it's not limited to statements in books, statements in newspapers, statements in magazines, statements on television, statements on radio, podcasts, YouTube, Rumble, or any other commercial or self-published media. I think that's not appropriate. I don't think that's not designed to remedy what they complained about originally. I handed you a list that I thought was the short list because that's the remedy that we thought the court would employ. So I have a problem with that. And then the second one is number 14. It's just way too restrictive. Condition, to add this as a bond condition. But the defendant shall make no social media posts of any kind, whether public or private, concerning any co-defendant or witness in this case. I think if we just had the original bond order, you can add the no physical contact with any witness, that would clear that up. And the communication part, you can add in no collusion with any witness. But in terms of him and in the list that I suggested to you, you say nothing about Ruby Freeman unless she has a few lawsuits pending. And if she were to say something, I would of course vet whatever was going to be put out there. But the idea being that he could respond and say he doesn't find this to be true, or he finds it to be true, or what have you. So I don't think 14 is appropriate because it's so restrictive on social media.
And again, give me specifics. What is it exactly that you think he should and wants to be able to do that 14 precludes?
If he wants to get interviewed by a reporter and to talk about how this case came about, what he did in this case, I can't believe the district attorney would object to that. They'd probably watch it and catalog everything he said. Or if he wanted to get on social media and say, Miss Willis is not a nice person. She did this, and she doesn't care what he says. She said that. But if he went on there and said, what she said about me in this case is not true, or what the evidence that I've seen on the internet concerning X, Y, and Z is not true, he should be able to respond to that. Otherwise, you're just muzzling him and stopping him from talking at all. That's what the state's order does. They want to muzzle him.
Ms. Willis.
Your Honor, this bond order does not mention District Attorney Fonnie Willis at all. I've stated on the record, he can say whatever he like on any post he'd like about me. I have no value for what he says, and I'm threatened every day anyway. So that he posts and I get threatened some more, that'll be what it is. I've learned to live with that, and I am a public official, and the voters elected me here, and I've put myself in this position. That does not give him the right to contact co-defendants or to intimidate other witnesses. And quite frankly, it's really in the defendant's interest to shut his mouth about this case because it can and will be used against him.
Should be complaining. So
the complaint is the harm that it does to the witnesses and the victims and the community.
All right. We're going to take turns. And the one thing that flagged to me, though, was whether this is going beyond the facts of the case as well, because one of the conditions here in 10 is shall make no public statement of any kind concerning any co-defendant. And so essentially, does that mean the expectation is Mr. Floyd, who apparently wants to be a very active voice publicly, does that put him on the sidelines if he wants to participate in dialogue about the 2024 election? Is that intended?
No.
Because one of the co-defendants would be a candidate in that election. And if you mention the 2024 election, is he not mentioning that co-defendant?
Like to add the sentence, he can promote defendant one as a candidate.
I guess what I'm getting at is before it was tied to kind of the facts of the case. And so it seems like we've gone a different direction in this one. And what we can also do is this one is more of a broader order. If we need, I would feel comfortable signing this right now as a provision to get us through today and through the foreseeable future. And if we need to come back and consider argument to modify, we can do that. I don't really see the harm in having such a blanket restriction in place for the next week or two.
Your Honor, the only thing that we would ask, because we want to make sure that they read it, is in exhibit number 16, provision number 16. That is something affirmative he needs to leave this courtroom and do. 12 hours, we believe, was generous. I don't see why it can't be done in 30 minutes, but we wanted to do that. So I wanted to bring 16 to your attention.
We have no problem, although 12 hours is a bit extreme since he lives in Maryland. He's going to be traveling for the next several hours to see his family. We've got the holidays coming up. You're not going to have any trouble with that, Your Honor. He's going to be deleting those posts. That's not an issue for us.
Well, I mean, theoretically, he could just go in the next room and it doesn't take very long to delete a post.
It's actually in the car.
Okay, but
I wasn't sure.
yeah, I don't think deleting a post is all that onerous. So bottom line, am I hearing there's no defense objection to 16 as written?
I have no objection to that.
Okay. All right. I think that, again, I too often I think we run into problems when if we all collectively are rushing. So I'm fine to sign this as is today, and I would be happy to entertain a second modification once we've been able to digest this, to consider it, and we can either hear argument, or we can do it through briefing, or we can even just do it through email. So,
respectfully, Judge,
sir,
why don't we just have a one-line order until the next hearing? He stays off social media, period, until the court has a chance to.
Well, this goes a lot further than just social media. And again, I think this is a comprehensive order. But I also still want to respect the general, again, like as I mentioned before, a defendant's general right to criticize and to proclaim his innocence. And also to have, well, and that's what I'm saying. Well, under the terms of this order, he can do it without mentioning co-defendants, witnesses, or unindicted co-conspirators. So it'd have to be in broader terms. If we can fashion language that is more of a carve-out, we'll work on that. But I think for now, in the short term, based on what we learned so far today and the prior history, at least for the next couple weeks, if not week or two, it'd be this.
Okay.
Thank you, Your Honor. May we be excused?
We also did one more thing. Sorry. Can we get a witness list? No unindicted co-conspirator number 23. Unindicted co-conspirator. I don't know who those people are.
It's in his discovery, but we'll point him to the right page.
I think the indictment co-conspirators had already been disclosed, as I
They
understand
have
it.
been disclosed, Your Honor.
All right. All right. I'll let the parties work that out. But for now, Mr. Floyd, you have a copy that's been provided by the state of this modified bond order. I'm letting you know that I'm signing it as written by the state, and it may be modified again in the future. But for now, everything in this bond order is going to be in place upon signature, and you'll be expected to abide by it. Is that understood? All right. Thank you, Mr. Floyd.
John Morrison. Thank you very much. Nice to meet you. Yes, sir. Would you be back with patients? Yeah. I'll get it to